Welcome to Inherently Distinctive.
Hello and welcome to Inherently Distinctive with attorney Mark Goodman. Mark's practice focuses on patent law, trademark law, copyright law, and business law related to innovation. I am your host, Kevin Rosenquist, and today we're going to talk about something that we touched on a little bit in previous episodes, the DIY versus hiring a lawyer, the high stakes of navigating patents and trademarks alone. Mark, welcome back. Good to see you.
All right, let's rock and roll.
Yeah, we talked about this a little bit. I asked you about patents and trademarks on this and about what can happen, but we're going to deep dive it a little bit more. So how often do you hear of inventors or business owners trying to handle the patent or trademark process on their own?
Here's what I'd say. Happens all the time. I totally get it because lawyers, one of the first things people think of when they think about lawyers, it's going to cost a lot of money, right?
Yep.
And so, yeah, it costs some money, right? I can't deny that at all. So I'm totally respectful and understanding of people wanting to try to do this, especially people that are maybe in that bootstrap of a new business, right?
Right.
I think if you have an existing business with significant revenue, what are you doing, right? Those people, most of those folks, quite frankly, are wise enough to understand, just hire a lawyer, take care of it right, and focus on building your business and what you do, right? But I'm respectful about folks that are trying to get things bootstrapped out of their own pocket, let's say, don't have revenue coming in to try to do this. But that said, there's problems that can result when you do that. So, yeah, I guess you want to think about what are some of those issues, right, Kevin? Did you have any specific
Well, that
ones?
was going to be my next experience.
Yeah.
What are the issues that DIY filings can get caught up in?
Okay, let's think of a few out there. One very on the patent side. This can affect DIY or others, but I think if you at least involve an attorney early in the process, you should get this issue flagged, which is that the patent system requires you to file an application early in the process. Because a lot of entrepreneurs would probably think, hey, why do I need to spend a bunch of money on Mark Goodman to file a patent application? That's stupid. Let me just get it out there and sell the product. And then if it sells like gangbusters, then I'll go hire Goodman and get the patent, right? Well, here's the problem. In the United States, once you start selling your product, you have exactly 1 year in which to file some kind of patent application covering this technology, or else you forever lose your right to do so. This becomes public domain. What? You done? Right?
Wow.
And
Can anybody else file a patent on that?
No, right? So
Okay.
That maybe, you at least have that, right? It just becomes public domain, open, right? Because that sale would be prior art on what someone else is going to do. Now, of course, in the real world, it can be mushier because someone else might file a patent application and argue that they've tweaked it enough that they're patentable over what you're selling. But just generally speaking, no, right? That technology is old now. But here's the reason, why would they set it up this way, right? I always explain the reasoning for this because I think it makes some sense and it helps people remember this. Because let's say you file a patent application, let's say you get start selling some amazing new product in the marketplace and you start making a bunch of money. And I look over and I go, wow, Kevin's got an amazing business going here. I want to get in on the action, right? Yeah. But I wouldn't want to step on his toes in terms of intellectual property. So, is it mark patent pending in on the product or the marketing or anything? No. And does he say it's patented or patent pending? No. I do a search even and we don't find anything. Well, I should be free to invest a bunch of money and go in and compete with you, right? This is America, competition, right? And it would be super unfair for you to then get a patent, kick me out of that space. Right? Because I've invested innocently, right? It's different if you're marking the product patent pending or you're describing it on your website as patent pending, whatever, and then I go launching into it. Well, then I'm doing so at my own risk that you might get your patent issued and then come get me, right? And that's completely on me for doing it. And so that's why we have to be on file early because it's noticing to the public that, hey, I'm either have a patent or I'm pending and trying to get a patent on this thing. But it is a very, very harsh rule. In the United States, you have that 1 year, and even worse, most other countries, you do not even have that 1 year grace period. So for most other countries, if you want to, and that could be a whole podcast on international patenting, that we can bookmark for another time. But most other countries, you have to file before your first sale of the product. So that's a big thing that can trip people up. Some other things that trip people up. One thing that is a little bit of an issue on trademark side, I'll move to that. You got to be really tight about, and trademark can be much more tempting on the do-it-yourself crowd, right? Is because people look at a trademark application, well, it's not nearly as complicated. You don't have to write a big document. It's forms and different information and uploading and that kind of thing. True enough. But there's some real legal consequences to what you put in there, right? And so one example is that the ownership has to be right. I've heard of a scenario where this was a case that got appealed up into the court system. Somebody filed an application in the name of the president of this company, not in the name of the company. And the president of the company himself is not selling that product. And then ultimately that trademark was held to be void because it was not the proper applicant, right? So you got to be thinking about what entities you're using for what. And so that's
weird. I wonder why they would have done that.
Yeah, they just playing fast and loose with this and filed it. And then, and I've seen stuff like that get messed up. It's not as easy as people think to get the right specimen to prove use in commerce and making sure it's matching out properly with what you're selling. You also have to consider the strategy of what goods and services description you're applying for. And those can sometimes span multiple classes of goods and services. So there's some stuff that you can get tripped up on. So if we think about patent and trademark, on the argument against do-it-yourself would be on the patent side, it's just flat out hard, right? It's writing a patent application, let me ask you this. Would you want to just go you went to college, right, Kevin? Would you want to write a term paper this weekend and have it to me by Monday?
Nope.
Writing a patent application is like writing a term paper. It's that big of a document, right? So do you really want to do that yourself, right? That's one. And then on the trademark side, it is more, forms and information. But my argument there is that, well, for the price of a trademark attorney to get it done, given the value, trademarks last forever. We talked about that last time. It's often your most important asset. It's like the price to value ratio. I think it's a really good value to hire a trademark lawyer. But obviously, I'm biased on this. Other pitfalls, this stuff is there's a lot of complexity, and each thing that you do or don't do will have consequences to it ultimately, and could have consequences for a long time. And if you're not immersed in this field, I don't know how you would know anything about those things.
Yeah. And what do you do for clients that helps to avoid these pitfalls we're talking about? How can you help to make sure that the process goes as smoothly as possible and increase the chances of a successful, patent or trademark?
We do this stuff over and over, right? Mm-hmm. So it becomes easy. It's almost like, I don't know, if you're trying to play tennis or something, right? And then you've never done it before, you look awkward and stuff like that, versus you get Serena Williams out there whipping the ball around. It looks like, wow, that looks easy to do, right?
Yeah, right.
But it actually isn't. We've done this all for a long time in our office. And so it's easy relatively most of the time for us. Right. And so that's part of it. And also some other things to think about is just flagging issues, right? Like that issue I talked about with the ownership of the entity ownership of a trademark. Well, that's something that somebody might just not even think of, right? I see a lot of people, they start businesses and they put it in their own name. They're the full owner of it. We can fix that. But that's you're just not even thinking of a certain issue, right? And then of course on the patent side, you got to think all about claim strategy and the type of things you put in the description. So like a little tidbit that I was always trained on is when we have a written description of in a patent application, we never want to say that some element that we're talking about is essential, critical, or must be there, right? Because if we say that, the courts have held that that's essential. You've admitted that that's essential, critical, must be there. And so then if you try to write claims that don't have that, well, that can be disallowed, right? Or you're trying to sue someone for infringement someday and they're like, well, they could look at it and say, hey, your application said that and ours doesn't have this. Well, but our claims cover, well, but you said that in your spec, right? So that's just stuff like that all throughout these processes.
And we talked about in our first episode about patents and just, there's a lot going on with a patent. I mean, like just when listening to you explain all of that, I just can't even imagine trying to sit down and figure that out. I mean, I think you used the example like the armchair patent attorney. Like if someone has the time and desire to go down and then basically just like learn the law, I guess that's fine. But I mean, come on.
It's a whole career, right? So, and it's a hard career too.
Yeah.
So, and again, I've seen people get things through, they're into it. And it's, like I said, some people will do this and probably always will do this. But, intellectual property, generally speaking, not a good do-it-yourself field.
How often do people come to you after they've either been denied or messed things up?
It happens from time to time. So I think more of my clients and potential clients are just coming to me straight. But I don't know, maybe I kind of armchair estimate it at around, 10 to 20% of folks that come in maybe have filed something or dealt with something on their own and kind of got to a sticking point.
Yeah, because I could see that being like someone going, oh no, kind of moment, like I am in over my head here. What are some of the other risks that may be there of trying to file a patent or trademark application without professional help?
And this sounds so simple and basic, right? But it's real, okay? Which is you're going to miss the deadline, right? There's going to be a deadline and you're going to miss it. Because like that's one of the biggest things that we have to do in the patent trademark practice is we have everything on these, we pay for these fairly expensive docketing systems, right? That automatically keep track of all of these cases and when the deadlines are, right? And, even though you'd think that would be the part of do it yourself that wouldn't be, you got a calendar, right?
Yeah, you got Google Calendar, right? Put it in your phone.
People get busy and then plus they get something and they don't understand it and they don't realize, it said you have to respond within 3 months or you need to respond within 6 months or you need to respond within 1 month, whatever it is. And they kind of, I'll get to this and they go back to other aspects of the business, whatever. And then that's actually one of the biggest pitfalls I've personally seen is where people like had some problem and then they just put it off. And then I'm like, we have to start this over again, right? Because we're actually past any deadline even that we could fix, right? The patent and trademark system, for the most part, like if you miss a basic deadline, it's just going to cost you more money and you can fix it. But if it goes further enough out, you're going to lose your rights at some point.
Right.
So I've even seen that where people blew way past. It's one thing if you just have to pay a late fee, okay.
Whatever, yeah.
Another whatever, fine, right? People grumble, but you got to do it, right? But when you get to the point where now you basically have to ask, file a petition and ask for permission and have all kinds of excuses of what happened, that's just, then you're spending a bunch of resources on something that isn't even substantive for your case. So that's another one.
So, you talked earlier about how people say things like, oh, it's too expensive. I don't want to spend the money. It's an attorney. They're always expensive. Can you kind of talk about the long-term cost savings when you do it right the first time?
Yeah. It basically comes down to that if you do run into certain problems, it can be much more expensive to fix it later, right? Like we just talked about, like, let's say you had, I had one example where somebody had filed their own patent application, it looks like, and then they had an office action. And then a bunch of stuff happened. It was like a couple of years later, this thing had been abandoned. So now we have to write an entire expensive document to try to make a bunch of excuses of why this wasn't taken care of earlier, which isn't even guaranteed to work, right? And so, let's say we've been talking about patents and trademarks. Like if in patent, sometimes you can't start over because let's say there's been a product put on sale or someone else has taken it. At a certain point, they'll say, no, we have to consider the rights of someone else that could look and say, your patent application is abandoned for a really long time. I should now have the right to go into this field, right? And so you can completely lose your rights on the patent side. And then, as well for trademark, you can just end up having to start the whole thing over. And then you have a much later priority. Now, trademark, at least you can start over anytime as long as you're selling. But then you are no longer maybe the earlier filing party against someone that has the same or similar name, right? You don't have the benefit of an early filing date anymore, which can, in the right cases, result in not getting your rights.
Just let the pros handle it. That's what I take from this episode.
Yeah, generally speaking, like I said, full respect for people that are bootstrapping up and just going to try this thing. I understand. I'm not, going to I want to denigrate that completely. It's just doesn't work most of the time.
It's complicated. Yeah. All right. Well, thanks for tuning in to Own Your Genius with attorney Mark Goodman. To connect with Mark, visit goodmanlawnevada.com, and please like and subscribe to our channel. Mark, so good to see you again. Thanks for being here.
This was fun.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.